Good day, friends. Hope you have liked my previous videos. If you like my previous videos, please do subscribe to this YouTube channel so that we can post more and more videos from time to time. So today we have come up with another judgment which has been recently passed by this Honorable High Court of Delhi on 13th of April 2022. This judgment is also available on the official website of the Honorable High Court of Delhi. So before going into the contents of this judgment, I'd like to draw your attention that a lot of the social networking sites and the Facebook groups have been posting the materials showing that wife has the right to some adverse comments have been made. So it's very much essential that before making any comments, we should go to the contents of the judgment. I have gone through this judgment. I don't find any adverse effects. Some adversities there on the judgment. Basically, all the evidences have been appreciated by the family court itself. The Honorable High Court has only upheld the order passed by the family court. So here what really has happened, the husband has made certain allegations of the adultery against the wife. So the Honorable High Court has found that these allegations were not raised before in the previous pleadings. So, and definitely who is making the allegations, the onus also lies on that party to prove his case, and also the opportunity must have to be given to the opposite party to disprove the allegation. So there is nothing wrong is there in the judgment. So the Honorable High Court have given the very correct view. Before drawing any conclusions, it's very much essential that we people have to first go through the contents of the judgment, what the judgment has really has spoken about. So this judgment, kindly see the contents of this judgment. This was a revision petition filed by the petitioner is the husband against the wife, against challenging the order of the family court, and which has awarded some maintenance against against the husband. So this was the challenge passed by the judgment passed by the 31st July 2020. The order passed by the family court. There was some factual matrix of this case is there, which is that the marriage took place on 9th April 2000. So almost 22 years have passed, and there was a series of the litigations there between the parties. It means both the parties have filed a series of the litigations against each other. So around 16 litigations was filed between the parties. So this was the instant petition filed against the family court order, in which the 125 CR.P.C petition filed by the respondent wife was allowed by the family court judge, and given the direction that husband should pay this rupees 6,000 from this date to this date, 6,000 from that date to this date to that day, and 7,000 from this date to that date, and from 15,000 onwards from 1st August 2020 till the life of the respondent or her remarriage. This was the submissions given by the this was the order given by the family court, and the submissions was there before this Honorable High Court was there. These were the grounds which were raised there before this Honorable High Court, that is, this judgment is patently wrong, perverse, and liable to be set aside, and the wife is capable to maintain herself, and has also been maintained by her father and the brother. But though in the cross-examination it has not been come out, the wife says she has been disowned by her father and living separately. This was the case, and further grounds were also made that the respondent's wife left the company of the petitioner without any sufficient reasons, and this was not appreciated by the additional principal judge, and also the learned family judge has also not appreciated that the misconducts of the wife, misdemeanor, and the abhorrent acts of the wife. And because of this conduct of the wife, respondent own parents have been aggravated by the respondent behavior and the cruelty. This was the grounds which were raised before the Honorable High Court of Delhi that the family court has not appreciated these facts. So, on the contrary, another allegation was also made about the adultery. So, but on the opposite counsel have made the allegations that the respondent is just making the allegations first at the time. These were never been raised before at the time of in the pleadings, and the respondent was not given even the opportunity to cross-examine the petitioner. So. The petitioner has also filed a case of theft on the basis of which the respondent wife was arrested and finally acquitted in the year 2016. And further assumption was there that he is holding, that the petitioner husband is holding a good post and is drawing a salary of rupees 2,50,000 rupees. This was the contention. A finding and analysis, the court has made the analysis of the 125 CR.P.C, which we are not going in detail, and the court has said that the grant of the maintenance by the husband towards the wife is legally bound to maintain it unless covered by certain exceptions which are defined in the section 125 CR.P.C. And the petitioner is challenging. Here the court has said the petitioner is challenging the order of the family court on the grounds of desertion, cruelty, adultery, and is capable to maintain herself. And the court has held that there is plenty of the judgments are there which the Honorable Supreme Court and even the High Court has clearly held that even the divorce proceedings were allowed. That does not disentitle the wife to get the maintenance on the ground of the cruelty. If the divorce petition is allowed on the grounds of the cruelty, then also the wife is also not disentitled to get the maintenance just merely because the husband succeeded in getting the divorce on the grounds of cruelty. This was raised there. However, now the court has held the petitioner was living under adultery. Neither did he added the ground on the pleadings nor respondent put to notice about the cruelty. So the court has held that the lapse has been committed on the side of the husband, because even if he wants to prove his case, he first has to insert these allegations in the pleadings. Then the wife, the opposite party must have granted an opportunity. So I don't think any wrong is there. This portion is legally correct. And this was also said that then even the son has also deposed in his affidavit, but the court has says this allegations was belated one and respondent was not examined on the grounds of cruelty, and the son who was staying with his father was not an independent witness, because there is a high possibility that the son may have got tutored by the husband, by the husband. So the court has clearly held, and 125 CR.P.C says the burden of the proof. Suppose if son is making the allegations of 125 means grounds of the adultery, the onus of the proof, the burden of the proofs lies on him who is making the allegations, the husband. So here in this case also the allegations, if he is making the allegation of the adultery, the onus of the proof also lies on the husband in this case. So apart from this, the several judgment has also been discussed by the Honorable High Court of Delhi, and which were passed by various other high courts across the country. This was the Bombay High Court. It says that Padurang Bakru versus Veera Padurang and Nathe. The court has held that living in adultery means the sporadic instances of the relationships between wife and the person other than husband would not fall within the ambient of the expression living in adultery. Means one or two sporadic instances will not comes within the definition, within the expression. So not the definition, the expression of the cruelty. This was the one judgment discussed by the Honorable. Another is Sandha versus Narayana. This was a judgment given by the Kerala High Court. It says the living in the adultery means there must be the continuous course of the conduct, in spite of in the state of quasi-permanent union with the adulterer. There must be continuous course of action. So this another judgment was Ashok and Anita. The living in adultery connotes a course of adulterous conduct, more or less continuous, not occasional. Here also the court has held, the Madhya Pradesh High Court has, Occasional acts can be, this must be a continuous act, not the occasional act. So various judgments are discussed by this. Another judgment was passed by the Honorable Madhya Pradesh High Court, Sukhdev versus Pukhalal versus Rekhalal versus Oakley. The court has said that unless at that relevant time, the wife was actually living with her adultery, she is not disentitled to the claims of maintenance. The burden of the proof of such adulterous conducts is on the part of the wife is upon the husband. It's not just he is making the allegation; he must have to prove this case. So the court has held the based judgment interpreted by the West High Court of the country evinces that only the continuous and the repeated acts of the adultery and the cohabitation of the adultery would attract the rigors of the provision of the intersection of the first case. However, the grounds taken by him does not establish in the prime facie that his was living in the adultery. The court has not agreed that, the court has only held that various other high courts across the country has said something about the living in adultery. But here in this case, the husband even failed to prove the prima facie case. Husband has not even to prove their case. So the court has not found any adversity there in the order. The court has said the additional principal judge has rightly observed that the petitioner has sought the divorce on the grounds of cruelty. He could not have the simultaneously urged that the alleged desertion of the respondent. So another ground was raised that she should be disentitled for the maintenance on the ground of desertion. The court has said, Honorable High Court has said, at the time when he has taken the divorce, he must have also raised this ground of the desertion. Now he simultaneously cannot made another ground of the desertion at this time because he succeeded in getting the divorce on the grounds of cruelty. Now he can't add another more ground here. This was the point which was now the final conclusions were there that the additional principal judge has, while passing the order, has taken into all facts, circumstances, arguments, material records, and the law laid down by the judgment passed by the West on the High Court. So the court has well appreciated all the consequences to which the reasonable judgment and the order was passed. So this was the point raised. So the court has not found any merits there in the revision petition filed by the husband, and it's accordingly dismissed. So this was the video which I have made. I have given the right picture. So unless we have not seen the contents there, which is available in the judgment, it's not correct to make a healthy comment without seeing the contents of the judgment. So here, everything has now been cleared. I hope you have liked this video. If you like this video, please like and subscribe and share this video so that we can. It encourages us to post more and more videos at appropriate time. So thank you for giving valuable time. Bye bye.